Let's bring in Chris Daw, criminal barrister, KC. Afternoon to you, Chris.
Good afternoon, Ian.
We just mentioned those, your favourite four letters, ECHR there. Are you speaking to us live from Strasbourg? I know you love it that much over there.
Do you know, I have been to Strasbourg, and it's one of the most beautiful cities in Europe and a very civilised place to go. But I'm actually not there right now. I'm in the cold of just west of London.
All right. Listen, so tonight there's a vote, or 7 o'clock this evening. Rishi Sunak is still, and his whips and his clerks and goodness knows who else are doing their best to muster support from some of those backbenchers. But of course, there's trouble at mill over there at Tory HQ, because the Tory party is not one party, it's many sort of subdivisions of one party, and they're fighting like ferrets in a sack at the moment. Can you identify who is right in all of this at the moment?
Well, those who rightly state that the legislation in any form will breach the European Convention of Human Rights and the United Nations Convention on Refugees are right. Those who say that this legislation can somehow avoid breaching those two vital pieces of human rights and refugee international law are wrong.
So even if you go with the kind of the left wing of the Tory party, those that are saying, look, actually, ideally, we probably wouldn't have Rwanda at all, but we will hold our noses a bit, we'll vote for Rishi's bill, because there is a clause in there, it's called Clause 4, as I'm sure you know, which allows appeals for those that feel they have particular circumstances to appeal against deportation. Even that lot are wrong.
Yeah, they're wrong for the simple reason that the reason why the Supreme Court struck down the original Rwanda scheme was principally, it was twofold. One, because the Supreme Court assessed all of the evidence, and we're not now talking about politics, we're talking about evidence, real evidence of what really happens in Rwanda to political prisoners, what happens to refugees who have been sent there by other countries, including Israel, who were sent back to their home countries without the permission of the state that sent them.
Well, so the United Nations, even, Chris, who sent, I think, 650 asylum seekers to Rwanda.
Well, very different, because it entirely depends on the circumstances in which they're received and the way they're treated thereafter. And the reality of this is that the Supreme Court struck down the legislation for the two reasons I was about to give you. Firstly, that they found that Rwanda fundamentally does not have the structures of law and justice and human rights which meet the standards required under English law, and not just the European Convention, but English law full stop. The Supreme Court found that it didn't meet those standards. And secondly, the Supreme Court found in practice that Rwanda had historically repeatedly broken promises not to send people back to countries where they may be subject to torture or other forms of mistreatment in their home countries. Rwanda has sent them back regardless, even in breach of international obligations. So the Supreme Court made it very clear, based on the evidence, that Rwanda is not a safe third country. And the problem with this legislation is the legislation says it's basically having legislation that could declare, for example, pork to be kosher. Just because some legislation says something, if it's fundamentally untrue, the courts in the end will find a way to unravel that legislation. That will be stuck in legal challenges for months and months and years. And so the whole legislation, frankly, is a political gimmick that will go nowhere, whatever happens tonight.
There it is. Well, Ben Harris-Quinny from the Bow Group is also with us. I mean, there is agreement here, because Ben also thinks it's a futile, ridiculous policy, but perhaps for different reasons, Ben. But this business of a safe country thing, I see lots of glossy brochures and images and even TV ads saying, come to Rwanda, it's a lovely place. There's people that, you know, have wonderful experiences there. Some former Brits are expats over there now. I mean, is it really a danger zone to anyone who goes there, as Chris suggests? And Chris is really echoing. No, I was about to qualify that, Chris. You're echoing the views of that court judgment that said that it's not a safe country.
Well, I mean, unfortunately, in the interest of debate, I do agree with Chris on a lot of the points, but as you say, for different reasons. The problem with what Chris is saying is that ultimately the primacy of decision-making and the accountability must rest with the British public. So there should be no situation whatsoever where a court here or overseas trumps the will of the British public. And that's why we have a legislature. So other people can take the view that Rwanda's safe, not safe, whatever. What the British public are saying is that we want to see an end to illegal immigration, which most people take the view that people that come here without a visa and claim asylum should not be doing that. Most people, 70% of people, do not back mass immigration, want to see immigration overall fall. And for 30 years, nigh on 30 years, those wishes haven't been honoured. So I would challenge the question of who has primacy, whether the courts here or in Strasbourg have the right to strike down the will of the British public. They don't. And whatever treaty we've signed up to, you know, the government may have signed up to many treaties. If the British public don't like them, they should undo those treaties.
There it is, Chris. It is the primacy of policy should not be decided in a courtroom, either here or in another country. It should be decided in Parliament.
When your contributor says whatever treaties we've signed up to, what he's talking about is the United Nations Convention on Refugees, which was instituted in 1951 by the British as a result of the horrific events of the Second World War, to ensure that those who claim asylum simply have the right to access due process when they land somewhere. The problem here is not Rwanda. The problem here is we don't have a functioning asylum system in this country. If we did, it would be able to assess claims within 28 days, make an initial ruling as to whether someone should be entitled to stay as a refugee. And if they want to appeal, they'd have another 28 days. After 56 days, they'd either be sent back where they came from or they'd be allowed into Britain as refugees. The problem we've got is that we've spent hundreds of millions on a crackpot, batshit Rwanda scheme, as even the Home Secretary has called it himself, instead of spending the same money to get all these tens of thousands of people through the system in a matter of weeks, and then the British public would get what they want, which I assume is not that we refuse all refugees or that we send genuine refugees to Africa, which is not the way that British public ever think about anything in my experience. What the British public want is a functional, efficient asylum system that has bad claims weeded out and send the people back, and has the good claims for good, honest refugees who genuinely face torture in another country allowed to come to Britain, as we've always done and any civilized country will do. So let's forget Rwanda and start focusing on what your contributor rightly says is the problem. The British people want to see an end to asylum seekers taking years and years to get through the system. In the meantime, some of them committing crimes and many of them in the end having their claims rejected. If we could get them all through the system within weeks, the British public could sleep happily in their beds knowing we were doing the right thing instead of becoming international human rights pariahs, which is what we're going to become tonight.
Okay. Apologies for the slightly salty language there, Chris, but I know where you were going with it.
The Home Secretary.
I appreciate that, but just for the weak at heart that may be offended. Ben, just on that final point, I mean, Chris mentioned, you know, we were signatories to the initial Human Rights Act. Everybody, whoever they are, whether it's us, whether it's them, whether it's a group in the middle, we all should have a right to a fair hearing and legal recourse. If we land somewhere and want a process to begin, we should be entitled to that, which essentially is what this is all about.
Well, look, 3 brief points on that. Firstly, I would argue that things have maybe changed a little bit since 1951. The numbers we're dealing with are very different to what they were then. I would like to see a system, as I say, where asylum claims are dealt with offshore in our embassies and consuls, the nearest to where people are making the claims, and anyone who comes without that approval is automatically refused. And that doesn't mean we don't take anyone. It means we take people using that process, and we discard people that come here illegally, because there has to be rules. We all have to abide by them. We can't, you know, zip off to a country illegally, and no one else should be able to either. But ultimately, the point is really who has primacy. So if we've signed up to something in 1951 or in Dublin or in Marrakesh, the British public should be able to say, actually, we don't agree with that. We want a different policy. And that must always have primacy, unless you don't believe in democracy.
Indeed. Listen, Ben, thank you. Chris Daw, thank you as well. KC with us on the programme.